Okay, guys, just as we're starting this sentencing, Ellis, the jury, has reached a verdict. So I will go right over to there because we've been on verdict watch since yesterday afternoon, and the jury has come back with a verdict. Now, her defense was not guilty by insanity, even though she did it and they know she did it. So what do you think the verdict is going to be? We are waiting for them to go live, but they haven't gone live yet. So we might just put this one on hold. If the verdict, if they go, once they go live, that's what I mean. Once they go live. Ew. Yes, about time. I mean, it's late in the afternoon. It's 2:37 p.m. Central Time. Now, they probably came up with a verdict a while back, but they're waiting for everybody to get to court. You know, the normal stuff. I mean, they've just announced it like 4 minutes ago. Hmm. Everything comes at one time, doesn't it, guys? We have a verdict. Now, they haven't even started with this one yet. I'm going to go over to the other channel to watch the verdict. I don't know when it's going to go live, but we're ready to go live on that, the verdict. Oh my God. I thought it might just be taking them a little while. They got some music on there, so I won't put the volume on because they have their music going. You know how it is. YouTube, news stations, and can have their own music, but they always like to get us on the music. So we'll put our own music on for a minute. Put some cocktail lounge music on. We're waiting for the live stream to go live. The verdict is in. Well, just look at the doggies. Look at them. I snapped that photo in the car. Don't they look so cute? When their eyes met. Yeah, these two mischievous fur buddies, Princess and Murphy. Now, Murphy is crime wine Murphy. Because he whines and he fights crime. And Princess is his partner in crime. She's the one that causes all the trouble. Starts all the howling, the woofing, the barking. And Murphy agrees. Yeah, they stick together. I've been doing a lot of shorts lately, so please stop over there and just check out the shorts. Give it a like. They're very short, indeed, some 4 seconds. But what can I say? So check out the shorts, guys. This channel's not all about crime. It's about life, travel, journeys. Life journeys.
talked to Mark, right? You text him?
I tried calling him and he didn't answer. He sent a voicemail. So if you want to shoot him a text,
Okay, I'll text him.
just tell him yes. I don't know how much room we'll have up in the court.
He's not allowed.
Tell him per the judge, he's not allowed.
Yeah, only starting sun down, buddy. No, I'm good, just waiting. Thanks. I got her all, everyone's squared away, I told everybody what we're doing. JJ knows how to do the seating, I don't know how. I wasn't here last week, so I don't know. Yeah. Yeah. I don't think they did before. I'll have to start with him. Because I wasn't here last week, I was on vacation, but I think it's put away, but let's see if this is there. Hey, Sergeant, she has a question about the phones. Yeah, hold on.
Same rules on phone. No phone. No phone? No phone. Unless it's a court staff. Contact.
It always happens.
Got to be with a note right there. Anybody available to assist bond guard or whatnot, please?
Nobody gets it. I get it.
Shame homicide.
Oh, yeah.
Can you help them out?
Yeah, I'll go down there. Hey, Bob, I'm gonna head down there. Give me a few minutes. You're welcome. Baumgartner is locked out. He needs an elevator from the 6th floor, so we can break out. Did you say the bottom or the top? Yeah, I texted him, so I caught my
Still waiting. We don't know how long we gotta wait, but I think the judge said something like he will give it an hour when the verdict comes in to make sure everybody can get to the courthouse. Not sure when the verdict came in though. Could have been 30 minutes ago. So stand by, guys. Just stand by. If you're on the replay, just skip forward.
Yeah, that's what they're saying. Yeah, I was gonna, this is administration now.
Got a lot of movement going on, guys. The camera keeps moving. I guess the jury was out a good 8 hours and 11 minutes and 24 seconds, give and take. 8 hours they were out. They started yesterday and most of today. So most of the deliberations happened this morning, started this morning, whenever, 8:30. I think that's enough time to go over everything. So I did a poll. It's an insanity plea at the time. Do you think the jury and the defense especially proved their case? Because the burden was on the defense to prove their client was insane at the time of that act. It was not on the state's burden to prove, it was the defense. Yeah, well, she's got mental health issues, but she's able to, she doesn't have a guardian where she has to be told what to do. She comes and goes wherever she wants. She traveled the USA. She was doing what she wanted. And if she didn't take her medication, that was on her. Now, in a lot of states, or all states, that if you do not take your medication and you commit a crime, you can't blame, oh, I didn't take my medication. No, it's on you. It's on you. Because this may have never happened if you were on your medication. Schizo, yeah. That's what she suffers with. She was diagnosed at the age of 19, they say. Well, some say 22, some say 19. But anyway, she was diagnosed. And if she thought that she didn't have to take her medication because she didn't need it, well, she's wrong. And she didn't take her medication the way she should have. That's on her. That makes her guilty, not insane. Okay, at the time. That's my opinion, guys. That's my opinion.
Oh, that.
We got this new thing. We have video. Yeah. That's what we should do. Because it's a video, not more just photos. Who said he was this call? Someone said he's not called. I read what she's fine, so. Yeah, thanks. Oh, I'm worried we're gonna be over here. Or we can just shut the door. Do I stand by the door? They're like, I need you out there. Hey, Jim. Kathleen.
Hi. Yeah, when you were afterwards. Oh, good. That's good. All right.
We're alone. It's a shotgun? You want to go there? I'm not sorry, Mom. Who is anybody? I'll speak on. Do you want me to come? Yeah.
I don't think you're.
Oh, yeah. Yeah, Oscar. Yeah, because you know how that's not what they do it.
No, he, and you know, he trusts you.
She used to be all right.
This guy, we would try all these cases together, and that was like our thing. I would feed myself, and he was just, I love him so much. They're kind of like, their show. Where's your phone?
I don't know.
My green phone.
Is that what it was?
Still waiting.
You can only do so much.
Oh, you're right. Yeah,
Brian was here with us, and you were here, we
I was on vacation last week, all week. And in January, I keep going to church. Supposed to go to DC, and they shut everything down. Hey,
Are you kidding? I gotta figure out.
we'll make one for Nando.
I gotta figure out how to do it.
He gets into it, it's new.
I mean, proper.
Yeah, whatever.
And would you say you missed this call?
Yeah.
All rise.
Cell phones off, please. Okay, Ash, thanks. All right, thank you. You may be seated. Kathleen, you're going to have to get. All right, so ladies and gentlemen of the jury, I've been told you have a verdict, and so I'll ask the foreperson to please provide the verdict to my bailiff. Thank you. All right, ladies and gentlemen of the jury, at this time, we thank you for your service. Again, I don't think any of us could go too far beyond saying that having you for 2 weeks, we know has been a cause for you to disrupt your lives, and so we thank you for your service. At this time, I'll read the verdicts on all charges, and then with respect to that, I will poll each of you just to confirm that it is your decision of this verdict. So with respect to the 9 counts and the furthermore, this jury says that they duly find and impaneled as sworn jurors in this case do find the defendant, Bianca Ellis, guilty of all charges. Those guilty charges also carry with it the furthermore that she did commit the other charge as requested with a finding of all 12 of you. So with that being said, juror number 1, is this your decision? Yes. Juror number 2? Juror number 3? Yes. Juror number 4?
Guilty on all charges. She is now being handcuffed.
Juror number 7?
They
Juror
didn't
number
plead
8?
that she was
Juror number
insane
9?
at the
Juror
time
number
of
10?
the act.
Juror number
And nor
11?
did I.
And juror number 12. All right, thank you. Again, I thank you for your service on behalf of Cuyahoga County and the 34 judges here. And we, at this time, will rise for the jury and we'll have a moment to speak to you afterwards. I'll have counsel to sidebar to review the verdict.
There you have it, guys. Many people will be safe without her walking the streets. And if you think you ain't gonna take your medication,
Everyone be seated.
Thank you. You can be
Think
seated.
again. Take your
All
medication,
right, so at this
people.
time, having an
This could be
opportunity to
you
review the
on a
verdict
prison.
forms, the court is going to set a sentencing date. I had asked the lawyers, I'm going to set it for October 27th at, again, 8:30 in the morning. I think we've been pretty consistent with being available at that time. I know that some of you have a trial calendar that might have some conflict. I'll ask that if you can discuss with the courts that you're currently going to be engaged with or potentially going to be engaged with. If I need to call any of those judges, I'd be happy to. But if we could do it, allow everybody that opportunity to be present as well. Anything further from the state of Ohio?
No, Your Honor, thank you.
On behalf of Ms. Ellis?
No, Your Honor.
All right, again, I thank all of you for professionalism as well throughout this trial. And so we'll recess at
Wow, guys. They just cut that off just like that. Just like that. But anyway, 27th of October, 2025 will be the next hearing, sentencing. So they're not doing that today. I don't know why they could. So another couple of weeks, she will be sentenced. And she's going to prison. You can't just not take your medication because you feel like, oh, I don't need it. You definitely needed it and you didn't take it. And the consequences were you committing a crime, not just any crime, a massive crime, ended a little 3-year-old's life. You stabbed him with that big butcher knife, and there was no hope for this little boy. He was dying right there on the ground outside in the parking lot. There was no saving this little boy. Even if he was in a hospital, in the emergency room, they couldn't save this little boy because the damage was already done. And so let's go back to the sentencing of this guy. I don't know if you ever heard of this guy. Let's get straight into it. Here he comes. Jesus. Look at all the tattoos, man. Ugh. My God. Ooh, look, he's got some top security there. Look at those sheriffs. They're loaded. I think they got grenades and everything. No. They're loaded, guys. Oh, look at him. Oh, yeah, he's smiling. He's happy. He's happy to be there, smiling away. Ugh. My God.
All rise. The District Court of Iowa in Fort Scott County is now in session. The Honorable Judge Whirling presiding.
Thank you. Have a seat, please.
Iowa. State of Iowa. Oh my God. Stop touching the mic, guys, in the courtroom.
Don't want you to talk. Mr. May. We are in court in cause FECR 436501, State versus Devon Braet. We are here for sentencing. Mr. Braet is personally present with his attorney, Ms. Amy Keats. The state is represented by Scott County Attorney, Ms. Kelly Cunningham. Ladies and gentlemen, this is a sentencing on a Class A murder amongst other charges. I do want to admonish the persons in attendance that at no time during this proceeding is it allowed for anyone to make any audible or visual statement of any kind, hold up signs, applaud or boo or anything. We must maintain decorum throughout this proceeding. Anyone who violates the rules of decorum can be held in contempt. So I ask you please to remain respectful throughout the proceeding. The file reflects that on July 11 of 2025, the jury returned a verdict in this matter under counts 1, murder in the first degree, count 3 and 4, a simple misdemeanor assault, count 7, going armed with intent, count 9, use of a dangerous weapon in the commission of a crime, counts 11 and 12, abuse of a corpse, count 13, arson in the second degree, and count, I believe it's count 14, possession of a controlled substance, third offense. We did have some renumbering of the trial information. Is that accurate, Ms. Cunningham?
And give me a moment, Your Honor.
Certainly.
Count 14 was arson in the first degree. So we've got abuse of a corpse for count 12 and count 13. I believe we did do some renumbering, but then arson in the second degree, is that what you indicated?
No, I think we're off. Let me just look here again.
Okay.
I have 11 and 12 were the abuse of a corpse charges. 13 was arson in the second degree. Originally, 14 was the dominion and control of a firearm, which I believe was dismissed by the state.
That is
so
correct, Your Honor.
15 becomes 14, and 15 had been possession of a controlled substance, third offense, which then became 14.
Okay, that is correct, Your Honor.
Thank you. Ms. Keats, have you had an opportunity to review the PSI with your client?
I have, Your Honor.
Additions or corrections?
Your Honor, on page, the bottom of page 3 gives the convictions. What is just above that, if that is the charges and not the convictions, then I would have no additions, corrections, or deletions. I'm looking specifically at page 2, count 3 is shown as robbery in the first degree. I imagine that is just what he was charged with. His conviction on that was a Class D assault. And that is correctly reflected on page 3, so that would be my one possible correction.
Counsel, if you look at the verdict that was filed, I believe, and correct me if I'm wrong, that he was convicted under counts 3 and 4 of a simple misdemeanor assault. Am I mistaken?
Your Honor, I am not able to pull that up at the moment. I believe the court is correct, though.
Ms. Cunningham, do you believe that it's a simple?
Yes, Your Honor,
Right.
it is a simple misdemeanor.
Right, thank you. Just to be sure, I don't want to overstate the charges.
Thank you.
Any other issues with the PSI?
No, Your Honor.
Any additions or corrections to the PSI from the state?
No, Your Honor, not from the state.
Are there any motions pending or any reason why sentencing cannot occur at this time, Ms. Keeps?
No, Your Honor.
What is the state's recommendation regarding sentencing?
Your Honor, recognizing that relative to the verdicts returned to the jury, when they received the jury instructions, there had been some renumbering that had occurred for the various offenses, and that was predicated on a couple of different issues. The state had previously tried Mr. Braet for felon in possession of a firearm prior to this trial. That arose from the takedown that was conducted by the Davenport Police Department at the Quick Star up by Menards. And so with that conviction, the state indicated that it would withdraw this felon in possession of firearm charge. The other issues too that would have resulted in a renumbering. In this trial information, both Ms. Blake and Mr. Braet were charged as co-defendants. So what would have been the original count 15, that would have been a possession of a Schedule II controlled substance, second or subsequent offense, that applied to Ms. Blake for purposes of this record, and of course the parties recognize this. When the trial initially started, it ended up resulting in a severance. And so given that she was found guilty in her trial, that was the other reason why we have a renumbering for counts. So I just state that for purposes of the record because presumably there will be an appeal, as there always is in these particular cases. And we just have that opener on the sentencing record so that then the parties are aware of that, and then they can understand the recommendations that are being made and how they correlate with the various offenses. So as to count 1, the jury returned the verdict of guilty to murder in the first degree. The state recommends that Mr. Braet be committed to the Director of Adult Corrections for the indeterminate term, well, not the indeterminate term, for life. This is a Class A felony, and it is not one that is subject to any type of parole. It is a conviction for life, and that would apply to the victim, Brian Goodwin. As to count 3, the jury found Mr. Braet guilty of the lesser included offense of assault under robbery in the first degree, and that would involve the victim, Brian Goodwin. The state recommends that he be sentenced for a period of 30 days incarceration, and I believe that there is the fine of $105 that goes to that. As to count 5, the original charge being assault while participating in a felony causing serious injury, and the jury came back with the charge of assault for Brian Goodwin. Again, the state recommends that he be committed for a period of 30 days and the fine of $105. As to count 7, and that would be the renumbered count 7 that went to the jury, that would be the charge of going armed with intent. He is an habitual offender. The state did set forth the habitual offender sentencing enhancement on the trial information, and then he did acknowledge that he was an habitual offender. The state recommends that he be committed to the Director of Adult Corrections for the indeterminate term not to exceed 15 years, obviously as a habitual offender. And I just speak to this, as a legal issue, because with him being sentenced to life in prison, it really is of no import, but he would be required to serve a minimum of 3 years. That would be subject to good time if he, before he could be paroled on that particular issue. Going to count 9, and that would be the use of a dangerous weapon in the commission of a crime. Again, that goes to the victim, Brian Goodwin. That is an aggravated misdemeanor. The state recommends that it be committed to the Director of Adult Corrections For the indeterminate term not to exceed 2 years, there is the fine of $855 that applies to that as well. As to count 11, abuse of a corpse, that was a Class C felony that was charged as an habitual offender, so the state recommends that he be committed to the Director of Adult Corrections for the indeterminate term not to exceed 15 years, and again, since he's being sentenced as an habitual offender, no fine would apply to that. As to the renumbered count 12, abuse of a corpse, the Class C felony is an habitual offender, and this would involve the victim, Amy Smith. Again, the state recommends that he be committed to the Director of Adult Corrections for the indeterminate term not to exceed 15 years, with no fine being imposed since he's being sentenced as an habitual offender. As to count 13, the finding of guilt on arson in the 2nd degree, the state recommends that he be committed to the Director of Adult Corrections for the indeterminate term not to exceed 10 years. This was originally charged as arson in the 1st degree. Since it was originally a Class B felony, there was no claim for an habitual offender enhancement to that. And so then the state would recommend the fine of $1,370 on that. And then going to the renumbered count of possession of a Schedule II controlled substance, 3rd or subsequent offense involving methamphetamine, that would make it the Class D felony. And again, the state recommends that he be committed to the Director of Adult Corrections for an indeterminate term not to exceed 15 years. And again, because he's being sentenced as an habitual offender, there would be no sentence that would, or no fine that would apply to that. As to all of these counts, the state is recommending consecutive sentencing. And you know, when it comes to the recommendation of consecutive sentencing, the state certainly recognizes that he's going to be spending the rest of his life in prison. But the nature of the offense that was committed and the impact that this crime had on the family of Brian Goodwin, but even the impact that this behavior of the defendant had on the family of Amy Smith and the community is one that is significant. The conduct was very egregious, and so this really is one of those circumstances that the state believes that consecutive sentencing is appropriate because it addresses the gravity of the crimes that were committed and how horrific those crimes were. Beyond that, Your Honor, the state has had an opportunity to review the pre-sentence investigation report. Certainly the state's given consideration to what we have in the pre-sentence investigation report. And one of the things that was documented in the pre-sentence investigation report that really, I think, lends an understanding of the type of behavior we saw Mr. Braet engage in this particular instance. This young man has a criminal history going back to 2001 and starting with arson in the 2nd degree and criminal trespass. And so then if you stop and you look at his juvenile history, we've got possession of alcohol, disorderly conduct, but we've got an animal torture case, we've got burglaries, we've got a number of different offenses leading from his juvenile years even into his adult years involving assaultive behavior. I mean, I could go through and I could recount everything, but I mean, there is that history of just a lack of regard for the rights of others and an ongoing history of engaging in abusive behavior of individuals, as well as the combination of his involvement with controlled substances, which was certainly a factor that was talked about in this particular case. And then when we get to December of 2011, we had the federal prosecution of Mr. Braet, where he had pled guilty and he was sentenced to conspiracy to distribute at least 28 grams of a mixture and substance containing cocaine base and a quantity of heroin. And then even after that, following his release from federal prison and then being on probation, we've got the firearm possessions, and then shortly thereafter we've got the commission of these particular offenses. So with that being said, the state believes that looking at the scope of his life, the behaviors that he's engaged in, this is an individual who is a significant danger to the community, and the recommendation of the state is one that the state asks the court to support. Beyond that, Your Honor, I would note this. I did also in the trial information set forth a sentencing enhancement for use of a dangerous weapon. So if an individual is involved in the immediate possession and control of a dangerous weapon, or that is displayed in a threatening manner, or they were armed with a dangerous weapon or participating in a forcible felony, there is a mandatory minimum that he would be required to serve, recognizing certainly that murder in the first degree is a forcible felony. And under section 902.7, I think that that requires that an individual serve a mandatory minimum 5 years, and that's not even subject to good time. And for victim restitution, would you like me to address that issue now, Your Honor, or just wait?
Oh, let's wait.
Okay. And there are family members, when the time comes, who would like to make statements to the court.
At what time would you like to have the victims make their presentations?
Your Honor, it's my understanding that procedurally now they will make statements after the parties make their recommendations to the court.
Thank you. Ms. Keats, does the defense wish to make a recommendation?
I would, Your Honor. Let me just start by directing the court's attention to the order nunc pro tunc of July 11th. It is docket number 2436. For reasons already stated, there's been some significant confusion regarding count numbers, and my understanding from the order nunc pro tunc is that Mr. Braet was found not guilty on count 4, which had been the robbery, and so the simple assault on count 4, I believe he was not convicted of.
No, it would be just the assault on count 3 and the assault on count 5, just
Correct.
in case counsel was confused.
Yeah,
I was.
Yes.
Three and 5, not 4.
Okay, thank you, Your Honor.
You're welcome.
Your Honor, we would ask for the minimum fines. We would ask that all of these counts run concurrent to each other. We fully expect the court will order a conviction on all of the, excuse me, not a conviction, a prison sentence on all of these. I would point out specifically for the court that abuse of a corpse in both decedents and arson were all the same act. And so particularly with respect to those, that would be an additional reason why we would ask for those matters to be concurrent to each other. I may have misspoken. We are asking all counts to be concurrent to one another, but specifically on both abuse of a corpse, on both decedents, and the arson in the second degree, because those were all committed from the same act. We ask that those specifically have that additional reason for being concurrent. Thank you.
Thank you. Does your client wish to address the court?
No, Your Honor.
Thank you. Ms. Cunningham, do you wish to have the victims make their presentations at this point?
Sure.
Would you call them?
Yes, Your Honor, the state would call Deanna Goodwin to the stand. She is the mother of Brian Goodwin.
Ms. Goodwin, would you please state and spell your first name for the record?
Deanna, D-E-A-N-N-A. My last name is Gott, G-O-T-T.
Thank you for that correction. Ma'am, I see you have a prepared statement. If you wish to read from the statement, you're perfectly welcome to do so. However, my court reporter has to take down what you say, and I know this is extremely emotional, so I'm going to ask you, please take a deep breath and read slowly.
Okay.
When you're ready, ma'am, thank you. Ms. Cunningham, unless you had some other statement you wish to make before the statement?
No, Your Honor.
Thank you. Ma'am, when you are ready.
I had the privilege of calling Brian my son since he was 7 years old. Our family consisted of mine, yours, and ours. Brian was the oldest brother. A few years after his father and I divorced, our bond became stronger than ever. Brian and his family made our family whole. This was and is our family. This was and is our family, the family that loves him and will never forget him. In 2024, I lost a son, a mother, and 2 very close friends. Only 3 of those deaths were natural causes. I had to get on medication for depression. Only 2 things kept me going. I knew I had to be strong for my kids, and I wanted to make sure justice was served for my son's brutal murder. A couple weeks after Brian's death, I got the courage to look at his Facebook page. At the time, it was the closest thing I had to be near my son. I seen a post that really stuck with me. It said, "When you die, God isn't going to ask you about someone else. He won't ask you about the 2 men down the street who got married. He won't ask you about the girl who had an abortion. He won't ask you about the atheist who lives on the corner. He won't ask you about the woman who feels more comfortable as a man. He will ask you how you love those people as you were called to do, and some of you didn't." That was 100% Brian. He loved everyone. If I ever needed anything, I knew I could call him and he'd be right there. As a parent, I sat here for all the first trial and some of this trial. I saw pictures that no parent should have to see. I listened to lies and I had to be silent. I watched as attorneys and a defendant laughed and joked around, knowing all the time that I didn't even get the chance to have a proper burial for my son. I couldn't even tell him goodbye. These ashes are all I have left of my son. And you still live on. I am not here to offer forgiveness. For the 2 people that brutally murdered my son and Amy, I wish I could ask for the death penalty. Your lives mean as much to me as Brian's and Amy's meant to you. It's sad knowing that you could have lived your life any way you wanted, and this is what you chose, to be a murderer. Brian and Amy will live in our hearts forever. They will never be forgotten. Your friends, your family will move on, but you will not. Every night you will look at your 4-cell walls knowing that's all you have left. This is the pathetic life you chose. And now, just like Brian and Amy, there's no escape. I hope you have the life and death you so deserve. Was it worth it?
Ma'am, sorry. Objection, counsel?
Your Honor, I would respectfully ask that the victim impact statements remain limited to the effect on the victims. That the code does not permit the wishes for the defendant's life in the future pursuant to Iowa Code 915.21.
Thank you. Ma'am,
I'm done.
you're done? Very well. The victim is done with her statement at this point. The court thinks it's irrelevant to make a ruling on the objection. The objection, therefore, is overruled.
Your Honor, the state calls Destiny Martini, Brian's sister, to the stand.
Ma'am, would you please state and spell your name for the record?
Destiny, Destini. You want my last name?
Please.
Martini, Martini.
Ma'am, likewise, I see that you have what I believe to be a prepared statement, which is fine. Again, I'm going to ask you to please take a deep breath. This is very difficult, I understand. And please give your statement slowly. If you're going to read, read slowly. Thank you, ma'am. When you're ready, go ahead.
I've avoided speaking out and being present for any part of this trial for many reasons. Watching Adriana's sentencing was excruciating, and I knew that I had to be here to speak Brian's truth. Brian was a brother, a husband, a father, an uncle, a son, a grandfather. He was a best friend to many people, but those people weren't like you and that trash co-defendant of yours. Brian's only flaw was that he would help anyone in need. Unfortunately, his kind heart led him to help two monsters. This entire trial was based around my brother and his involvement with drugs.
Objection. Your Honor, I'd ask that the victim impact statement recite the impact to the victim, and I apologize for interrupting, but not to characterize.
Do you
the
apologize?
defendant.
Hold on. Finish your objection.
Not to characterize the defendant or express wishes for his future.
I believe that the statements that the witnesses were making were preliminary to the victim impact portion of her statement. The objections overruled. You may continue.
Your attorneys tried their best to paint this picture of Brian being just another addict. That couldn't be any further from the truth. Brian's life as an addict was short-lived. His life before that was something you have never had and you will never have. You and Brian are not the same. I was honestly shocked when I found out what kind of people were surrounding him during this time of his life. 9 months. 9 months is all it took for my brother to fall into a deep addiction and ultimately lose his life. He wasn't even given a fair shot at finding himself again, at finding sobriety. That was taken from him. That was taken from his family, his friends. My brother was the best brother anyone could ask for. He's 11 and a half years older than me. When I was little, he would race to the gas station, and he would always let me win. He would play games with me, carry me around the house inside of a blanket, and act like he was going to flush me down the toilet. He protected me. If anyone was mistreating me, I ran to Brian. He always took care of it. When I was scared at night, I'd run into his room. After high school, I was in an abusive relationship. When he found out, it took a lot to talk him out of putting himself in a bad situation. If I had problems with my car, I called Brian. I don't live near here anymore, but if I called in to do something for our mom, he never hesitated. He went to 2 stores while he was sick to find her a cake that I wanted to get her. He was always there. Over the last few years of his life, I talked to Brian frequently. We were both going through things and leaned heavily on each other. I was 3 hours away, but he was always just a phone call away. We would spend hours on the phone at times talking about life, the past, the present, the future. He gave me advice that nobody else can replace. He gave me comfort that nobody can duplicate. He was my rock. We were so much alike in so many ways. I would often call him and just ask if he liked a certain food that I didn't, and sure enough, he didn't either. Even the popular things like QC pizza and cornbread. I had 3 people I could always count on. My mom, my grandma, and Brian. Brian's addiction isn't my story to tell, but I can tell you that wasn't even a fraction of his life. He was married to a wonderful woman, raised 3 amazing boys that he had custody of, and had a great job with the county. He had every opportunity to turn out like our father. He didn't say, just because someone has a perfect life and everything in the world going for them, that doesn't mean that one mistake cannot lead to the hole that addiction can have. I knew Brian had struggled. He came to my house to detox about a year or so before his murder. He wanted to get clean. At the time, meth was not in the picture. He had a lot of changes happening in the hurt of losing our father. When he stopped answering my calls and calling me, I honestly thought it had to do with his girlfriend. I had no idea that he was struggling the way that he was. On August 17th, he told me that his life had went to hell. I truly believed he was talking about his relationship and his marriage. For the rest of my life, I'll have to live with regret that I didn't reach out to him and find out what was really going on. My brother was suffering, and I didn't even know. I passed by his house a few times when I was visiting my mom and considered stopping, and I never did. I feel like I failed him in ways that he would have never failed me. At the same time, his lack of communication was likely another attempt at protecting me from his situation and from people like you. You are a vile human. To walk into someone's home with some little girl and try to take over, what was your goal in all of this? What other outcome did you think was going to happen? Why was Amy and Brian's life worth taking? They were innocent people, humans. They are loved. Brian opened up his home to you both. How could someone like that be a target to be murdered? I will never understand people like you and Adriana. To think that if someone lives or dies, that was not for you to decide. Their lives were not for you to take. Brian and Amy had the chance of finding themselves again. They had reasons to live. They had reasons to find sobriety again. Their lives were not meant to be over. I need my big brother. You took a part of me that day that I will never get back. And you couldn't just take their lives. You had to destroy their bodies. I had to sit in a pew at his funeral, stare at a box and a picture. I don't even know how my mom was able to watch Adriana's trial or how Sally could sit through both trials. I got a glimpse of my brother's charred body from a live video of the trial and I lost it. That was not supposed to be how his life ended. You couldn't just stop at taking his life. But you took our ability to get closure. You took my last goodbye. Even that little degenerate girl took everything from us. His possessions are gone. His body is gone. His life is gone. All I have left of Brian is a teddy bear that he gave me when I was little, a bag of ashes, some pictures and memories. You had nothing but time to think about what you were about to do to Amy and Brian. Even after Amy's killing, you had plenty of time to think and realize what you did was wrong. Yet you still chose to take my brother from me. Now you'll have nothing but time to think about what you did as you sit in a cell and rot for the rest of your life. Here's my wish for you and for that co-defendant of yours. I hope that you both live very long, miserable lives. I hope you meet your match in prison. I hope you were tortured and you have to live through it.
Counsel?
Same objection, Your Honor.
The court understands the objection and the court will take into consideration the statutory requirements for victim impact statements in its sentencing in this matter. The victim can continue. Go ahead, ma'am.
Day in and day out. The thing about people like you, people start to forget you even exist. You're locked away, sitting in a cell, rotting. The news will stop covering this story. Your friends will stop writing and calling you. Family will start making excuses on why they don't visit, or maybe they won't visit at all. However, Amy and Brian will never be forgotten. They will be remembered forever. They were and will continue to be loved. You and Adriana will be forgotten. Your names will never be spoken from the outside of those cell walls again. Last thing, fuck you. I hope you rot in hell.
Objection, Your Honor. Your Honor, not only is the victim impact statement supposed to help the court and guide the court in its ruling, it is what the defendant is required to listen to, and he has rights, and he should not have to sit here and listen to such statements with the license and consent of the system.
The purpose of the victim impact statement is to elucidate the court as to the sentencing options before it. The defendant has been convicted of a murder in this case, and the outrage of the family members at that murder is not an appropriate factor for this court to take into consideration. The court will not take that into consideration. However, the court will allow the victims to speak. Thank you. Ms. Cunningham, any further victims?
Yes, Your Honor. The state calls Amy Smith to the stand. That would be Amy's mother. Oh, I'm sorry, Sally. Sally Smith, I'm sorry.
Thank you.
Amy Smith's mother, thank you.
Yeah, probably.
You would you please the box over with counsel?
Thank you. Okay.
Ms. Smith, when you are ready, speak slowly, please.
Okay. I thought I would have more time. I miss her. She was a beautiful person and she loved fiercely. She was a daughter, sister, niece, and most importantly, a mother. Her daughter is here with me. Her name's Violet. She's 14. She wants her mom. But you took her. You just took her. Why? I don't get it. I know that I'm supposed to just speak on the abuse of a corpse because you were not convicted of her murdered, but I just don't understand how any person can do such a thing. She was a great friend. She put others first. She was generous. She would give you her last dollar if you needed it. I saw what you did to her. So evil. Pictures I had to look at, no mother should ever have to see. How could they? If I could talk to her one more time, I would tell her how much I love her. And I hope she knew that. See, I didn't see my daughter for several years because of her addictions, but I had faith that she would get clean and we would reconnect with her kids, her sisters. We all miss her so much. And Violet, she's got a lot of anxiety. She doesn't like to leave the house. In fact, I got her here today, but she basically stays in the house all the time. She's not even going to school. She's doing online school because she just doesn't like to go out. She's afraid. She has so much anxiety, it's ridiculous. But anyways, she just wanted to say, why? Why did you do this to my mom? I never got to see her and say goodbye. That's about it.
Thank you, ma'am.
And Your Honor, the last individual will be Sarah Womack, and that is Amy Smith's sister.
Ms. Womack, would you please spell your name for the record?
Sarah, S-A-R-A, Womack, W-O-M-A-C-K.
Thank you, ma'am. When you are ready, please go slowly.
The loss of my sister has left our family in a state of devastation that words cannot fully capture. The pain we feel is overwhelming, lingering with us each day as we attempt to find some measure of comfort and peace. Her laughter, her kindness, and her love were all taken from us in an instant, so suddenly and violently. That emptiness she leaves behind feels impossible to fill. Like many in my family, I had been estranged from Amy for several years before her tragic and untimely death. This distance did nothing to soften the blow of her passing, nor did it prepare me for the immense pain that followed. The trial forced me to confront the horrific reality of how you and your accomplice left my sister's body. The brutality of it all is beyond comprehension and is not something that anyone should remember about a loved one. To cope with the difficult memories of her passing, I keep a photograph of Amy that shows her beautiful smile. I place it somewhere where I can see it whenever the tragedy begins to overwhelm my thoughts. This simple act allows me to focus on the happiness and the light she brought to our lives, rather than the horror of how her life ended. I make a conscious choice to remember Amy as she was before her life took a difficult turn. Throughout this ordeal, it seems that the only thing anyone has wanted to talk about is her struggle with addiction. But our family knew and cherished a very different person than the one described throughout the trial. To us, Amy was a beautiful soul, a wonderful friend, and a devoted mother to her 3 children. Her memory continues to live on in the hearts of those who truly knew her. It is this Amy, full of love, warmth, and life, that I choose to hold on to and remember. Since her traumatic death, I have begun to suffer from anxiety and terrible insomnia. Concentration has become a struggle, affecting not just my home life, but also my work. It has now been 1.5 years since you took her from us, and the pain does not fade with time. Each day it feels as though I wake up in the same unending nightmare, and the grief remains as raw as ever. Given the gravity of your actions and the irreparable harm you have caused our family, I respectfully ask the court to impose the maximum sentence permitted by law. The harshest punishment available is the only measure of justice left for us to hope for. Even so, it cannot truly balance the loss we have suffered, as it still allows you to continue living. Your attempt to evade justice by fleeing was rewarded by the diligence of the Devon Police Department. And now a prison cell measuring 6 by 8 feet will be your reality for the rest of your life. This is the consequence you must face for your actions.
Thank you, ma'am. The court understand that concludes victim impact statements?
That is correct, Your Honor, and then the state does have information relative to restitution.
Let's take that up now.
Okay, all right, Your Honor. Relative to the family of Brian Good, and under Chapter 915, I believe, where there has been the death of a party, the defendant is required to pay $150,000 to the heirs of Brian Goodwin. He would be jointly and severally liable for that amount with his co-defendant, Adriana Blake. Obviously, we've had the sentencing in Ms. Blake's sentencing, or for Ms. Blake, and that has been a provision that was set forth in the sentencing order. As for the heirs of Brian Goodwin, that figure then would involve distributions to the following individuals: Sarah Goodwin in the amount of $75,000, Bryson, B-R-Y-S-O-N, Tigges, T-I-G-G-E-S in the amount of $25,000, Seth Goodwin in the amount of $25,000, and Caleb Goodwin in the amount of $25,000. In addition, there was restitution paid by the Crime Victim Assistance Program in the amount of $2,676.96 to Seth Goodwin for lost wages as a result of having to deal with the issues involving his father's death. And so, with that being said, the state would ask the court to require Mr. Braet to pay that amount of restitution to the Crime Victim Assistance Program, recognizing too that Ms. Blake would be jointly and severally liable for that amount as well.
Does the defense wish to be heard as to restitution?
No, Your Honor.
Thank you. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
The court has taken into consideration the verdicts that were returned in this matter. The court also has heard the statements of the victims that have been presented. The court specifically comment that the court is not influenced in its decision regarding the sentence as to statements of vengeance or outrage from the victims. There are statements as to personal loss, and the depth of the personal loss are deeply moving to the court, and the court does take those into consideration in its sentencing. This is a somewhat complex, statutorily complex sentencing, so counsel, please pay attention. If I am misstating the recommendations of the parties in this matter, just interrupt and let me know.
Absolutely. So, Your Honor.
Mr. Braet, pursuant to the verdict of the jury in this matter, returned on July 11, 2025, as to count 1, it is the judgment and sentence of the court pursuant to the verdict of murder in the first degree in violation of 707.2 of the code that you be committed to the Iowa Department of Corrections pursuant to 902.1 of the code for the remainder of your natural life without the possibility of parole. You will be given credit for time served in the county jail in this matter. It is further ordered that you will provide a DNA sample as required by statute. There is no fine as to count 1. As to counts 3 and 4, pursuant to the verdict of the jury convicting you of the charge of a simple misdemeanor assault, as to each offense, it is the judgment of the court that you be committed to the Iowa Department of Corrections for a period of 30 days, that you be ordered to pay the $105 minimum fine, the 15% surcharge assessed by the clerk.
And Your Honor, that would be 3 and 5.
That's what I thought I said, but 3 and 5.
Yeah, I think you said 3 and 4.
Okay, 3 and 5, sorry, it is 3 and 5. If I said 4, that's an error. As to count 7, the offense of going armed with intent, it is a judgment and sentence of the court that you be committed to the Iowa Department of Corrections pursuant to 902.3 and 902.3 and 902.9 to the indeterminate term of 5 years, that you pay the minimum statutory fine of $1,025, the 15% surcharge assessed by the clerk of court, and that you provide a DNA sample. I believe as to that offense, there is a statutory minimum 3 years that must be served before the defendant would be eligible for parole as to that offense. Is that correct?
He was charged as an habitual offender, so it would be the 15 years, but no fine on that one since he's being sentenced as an habitual offender.
Thank
So
you.
that would be the indeterminate term not to exceed 15 years.
With a mandatory minimum of 3. So the court corrects its sentence. The defendant is sentenced to 15 years of incarceration, no fine, the 15% surcharge, and provide a DNA sample with a statutory minimum 3 years. The court notes that the statutory minimum 3 years, although it's required as to this offense, the defendant is also sentenced under count 1 to the statutory life without parole. As to count 9, use of a dangerous weapon in the commission of a crime, it is the judgment and sentence of the court that the defendant be sentenced to a term of incarceration of 2 years, that he pay the $855 fine, the 15% surcharge, and provide a DNA sample. Is there a 5-year minimum as to that offense, counsel?
It's the aggravated misdemeanor, Your Honor, so that would not apply.
Thank you. As to counts 11 and 12, the offense of abuse of a corpse,
And the habitual offender was charged with respect to both of those offenses, Your Honor.
it is the judgment and sentence of the court that the defendant be sentenced to serve a term of incarceration of 15 years as to each offense, with a mandatory minimum of 3 before he is eligible for parole. There is no fine. The defendant is ordered to provide a DNA sample, and the 15% surcharge is assessed by the clerk. As to count 13, arson in the 2nd degree, it is the judgment and sentence of the court. That was not habitual, is that correct, counsel?
Right, because it was originally the Class B felony, so that the state did not have the language for the habitual offender on that one, Your Honor.
It is the judgment and sentence of the court that defendant be sentenced to serve a term of incarceration of 10 years, pay the minimum $1,370 fine, the 15% surcharge assessed by the clerk, and provide a DNA sample. Finally, as to count 14, possession of a controlled substance, 3rd offense, a Class D felony as an habitual offender. Again, it is ordered that the defendant serve a term of incarceration of 15 years, pay the 15% surcharge assessed by the clerk of court, provide a DNA sample, and no fine is required in this matter. Further, the defendant will serve a mandatory minimum, must serve a mandatory minimum 3 years before he is eligible for parole as to that charge. As to the sentencings for these counts 1, 3, 5, 7, 9, 11, and 12, 13, and 14, as the court correctly entered the sentence from the attitude of the state?
Yes, you have, Your Honor. And then also there's the enhancement for use of a dangerous weapon under 902.7 that requires the imposition of the mandatory 5, and that's a hard 5 that would apply to the forcible felony.
The court amends the sentence as to count 9 to require a term of incarceration of 5 years before the defendant is eligible for release. Wait a minute, count 9 is a aggravated misdemeanor, counsel.
Yeah, our forcible felony will be the murder in the 1st degree. For all practical purposes, it has no import, but it was a sentencing enhancement that I had charged, recognizing that if the jury had come back on other forcible felonies, it would have application.
Thank you. Ms. Keeps, the sentence is, I'm not asking you if you agree that the sentence is proper, I'm asking if it is legal, if there are any other errors that need to be corrected before the court proceeds. Your mic is off.
No errors, Your Honor.
Thank you, counsel.
Done order.
Thank you. As to each of these counts, 1, 3, 5, 7, 9, 11, 12, 13, and 14, the sentences are imposed based on the recommendation of the PSI author in order to protect the public and based on also the seriousness of the offenses charged. It is further ordered by the court that each of these sentences shall be served consecutively, one to the other, for all offenses. The reason for the consecutive sentencing, thank you. The reason for the sentencing, the consecutive sentencing is based on the seriousness of the offense of murder in the first degree, also the serious impact of the remainder of the offenses, particularly the abuse of a corpse, that shocks the conscience of this court regarding the respect that should be given to any human being that was clearly lacking as to this defendant. Therefore, the court imposes consecutive sentencing. Ms. Cunningham, I just want to be sure, as to the possession of a controlled substance offense, the final offense for which the defendant was charged, my notes indicate that that was count 14 in the trial information. Was it 14 or 15?
It was actually 16, but with the state withdrawing the felon in possession of firearm, and since count 15 applied to Adriana Blake for possession of a Schedule II controlled substance, when it was renumbered, it went to the jury as count 14.
Ms. Keefe, do you agree? Your mic's off. Sorry?
Your Honor, if there's a particular docket entry, I could take a look at the renumbered, but I agree with the substance of the charges, yes.
Thank you.
Your Honor, the amended trial information is D1450. There may be another one.
I recall that at sentencing, I'm sorry, at the conclusion of the trial, count '15, which was the possession of possession of a firearm as a felon, was dismissed at the motion of the state. Does that comport with the defense's recollection?
It does, Your Honor.
All right. For purposes of the clarity of the record, count 16 in the amended trial information referenced by the defense is treated as count 14 for purposes of sentencing, just for clarity purposes. I think that's the best we can do at this stage. All right. Pursuant to Iowa Code Section 910.3b, because the defendant was convicted of a felony that resulted in the death of another person, you are hereby ordered to pay victim restitution in the amount of $150,000 to the victim in this matter. As indicated by the state, that $150,000 will be divided as follows: to Sarah Goodwin, $75,000, to Bryson Tigas, $25,000, to Seth Goodwin, $25,000, and to Caleb Goodwin, $25,000. Further, that the defendant will pay victim restitution to the Crime Victim Assistance Program in the amount of $2,676.96. And Ms. Keefe, I apologize. I should have asked you first if the defense agrees to those amounts and sums to be paid in this matter, or do we need to set that for a further hearing?
No objection, Your Honor.
Thank you, counsel. The defendant has been ordered to pay the minimum statutory fines as to the various offenses herein. The court waives the payment of all of those fines for the reason that that will allow any payments that the defendant makes to be paid to victim restitution rather than to fines. So the payments will go to the victim restitution as indicated. It is for
Oh, I'm sorry. I would note that we had initially put in a restitution order, but we made corrections to it. So we just submitted a restitution order that sets that forth for the court just to review and approve.
Very well. Thank you. It is further ordered that defense counsel shall file a notice of appeal within 30 days of today's date. Upon the filing of the notice, defense counsel is released from representation herein, and the Iowa Appellate Defender's Office is appointed to represent the defendant. Due to the indigency of the defendant, it is ordered that a transcript of all proceedings in this matter be made available to defense counsel at the expense of the state of Iowa. Mr. Braet, if you appeal this ruling, an appellate attorney is appointed to represent you, as I've just ordered, you may be ordered to repay the fees of that appellate attorney. When a claim for fees is submitted at the end of that appeal, the court will determine your reasonable ability to repay those fees. Because the defendant was convicted of a forcible felony, there is no appeal bond. And Mr. Braet, these are your appeal rights. Sir, you have the right to appeal your sentence to the Iowa Supreme Court. To do so, you must file a written notice of appeal with clerk of court within 30 days from today. Failure to file a notice of appeal will be deemed a waiver of your right to appeal, and you will lose that right. If you wish to appeal and you are indigent, you can make application for a court-appointed attorney and a transcript of these proceedings at the expense of the state. However, all of this must be done within 30 days of the time limit, within the 30-day time limit I have just indicated. Further, the court has already ordered defense counsel to file that notice of appeal and ordered the appellate defender to represent the defendant as to that appeal. Lastly, due to the defendant's incarceration, as to Category B restitution for the costs of this action, the court finds that the defendant is not reasonably able to pay the costs of the action. The court sets his liability for Category B restitution at $0. Again, so that any payments the defendant makes will go primarily and principally to victim restitution. Ms. Cunningham, as to the sentencing, is there anything the court has neglected or overlooked?
No, Your Honor.
Ms. Keeps, is there anything that the court has neglected or overlooked?
No, Your Honor.
With that, we are adjourned. Thank you.
In order to return our PSIs into the court.
Yeah, if anyone has PSI, return it to the court, yes, please.
Thank you, Your Honor.
Is this your microphone? Just want to make sure you don't need it.